time when he suggested to, and this might be a tricky word to introduce, I would have preferred if he had said acknowledge or recognize the application of some Sharia provisions under English law. Indeed, if we are talking about Sharia in Europe, it's a matter of fear. Many people would, as it was said, perceive Sharia to be the very contrary of democratic, secular rules, of the rule of law. So we do have, for example, in Europe some right-wing and explicitly anti-Islamic parties in Switzerland, in Austria, here in Belgium, in the Netherlands, in Denmark, etc., etc. In Switzerland, there was one who had the slogan in the polls "Maria" instead of Sharia, "Daham," which means at home in Austrian dialect, "Daham" instead of Islam. So you see this kind of very simplicist arguing against a phenomenon which is called Sharia. And on the other hand side, we do have some extremists within the Muslim spectrum who in a way try to affirm this kind of fears. We have this small, it's a tiny group, but nevertheless I think we should care about these people. Sharia for Belgium, Sharia for the Netherlands, etc. And if they are talking about Sharia and what they understand about Sharia should really cause fear among everyone. And it's first Muslims usually who are targeted by these extremists, because these extremists are not only intolerant towards Christians, towards adherents to other religions or atheists, but to all Muslims who are following a way of interpretation of Sharia different from theirs. So it's not easy a talk if we are trying to define, to talk more precisely about the scope and the limits of Sharia, of the application of living Sharia within a Western context. But first of all, we have to know what is Sharia. And there, the difficulties already start. There are two fundamentally different perceptions of what Sharia is. And if we don't make clear from the very beginning what kind of perception we follow, this will inevitably cause misunderstanding. So there is a perception of Sharia in a broad and in a narrow sense, and I will try to explain both of them, and then trying to develop the legal framework within which Sharia rules can be applied, to be distinguished between religious ones and legal ones, and then I try to find a conclusion. But then, what is Sharia? Sharia in a broad sense is the whole system of normativity of Islam, which means the religious commands as well as legal rules, but not only the norms, not only the commands and rules, but much more the system, how to find them, how to interpret the sources, which is a highly elaborate system which was developed tracing back to the 8th century AD, which means the 2nd century of the history of Islam. So it is the mere contrary of a legal textbook. If you enter a bookshop asking the storekeeper, please one sample of the Sharia, you will make his eyes bright, because selling 10,000s of volumes, I mean, this is a really good business for him or her, which shows that this is a system, a highly dynamic system, rather than a fixed textbook. So it's religion and the law of Islam, and the system of interpreting it. Sharia in the narrow sense is very often used in a European non-Muslim context, but also among quite a number of Muslims, particularly from Turkish origin. You know, Turkey has abolished Sharia as a tradition, at least as a legal tradition, in the 20th of the last century, in a clear attempt to westernize and in a way to cut the previous heritage. So Shariat in the Turkish context usually has a negative tone, not necessarily among everyone there, but if you enter universities, if you are looking in the curricula, Sharia usually is banned to be a historical phenomenon rather than something contemporary. In this narrow sense, Sharia is reduced to the, indeed, from a modern perspective, intricate issues of family law, inheritance, and here we have to know that despite a number of reforms in a number of so-called Islamic countries, these rules are still gender biased and religion biased. So no equal rights for both genders. Every gender, male and female, have their respected role within the system in family law, but the roles are not interchangeable. So it's patriarchal system, which we were familiar to in Europe until a few decades ago. The same is true for the relations between the religions. So in these Islamic states, in case of conflict between two normative systems, it will always be the Islamic one which prevails. For example, in interreligious marriages, which are possible under Sunni Islamic law between a Muslim male and a non-Muslim female. The Shias wouldn't allow that either, but this is possible. But of course, then the relations between the spouses are governed by Islamic law rather than the Christian laws we have in this region as well. There are other aspects, namely the draconic penal law rules, which are partly, if you take it literally, derived from the Quran, which is the main legal source as well. There are not many legal verses in the Quran, possibly some dozens of them. But of course, if there is something legal, it is the highest and most acknowledged source for Islamic law. And there we do have these draconic punishments, cutting off the hand of thieves, according to Surah 5, verse 38, for example. Traditional interpretation tried to restrict the application of this rule as far as possible. You can prove that if you go into the sources, if you see what kind of prerequisites are required before the application of this penalty. Nevertheless, there are some so-called Islamic countries who still stick to this kind of draconic rules or reinvented them, like Iran, for example, in 1982, or some northern Nigerian states, very often due to political reasons rather than to due legal interpretation. And this would, of course, cause tensions from a human rights perspective. We should also not forget that if we evaluate any legal system on the world, it would be scientifically unacceptable to do it diachronically. So to compare the Islamic past, let's say, to the European present and vice versa, because things are developing, and this is true for the so-called Islamic world as well as for Europe. So if we measure systems, we shouldn't think that they are essentially immutable, unchangeable. This has never been the case for Islamic law, as far as I am informed about it, and I'm dealing with the issue now since more than 3 decades, nor for European law. So indeed we have to thoroughly look at what are people actually saying, how do they interpret, how do they apply the rules, and you will find out that within the Islamic world there is a broad range of very different interpretations of the very same Sharia rules. Let me give you only one example concerning Islamic family law, namely polygamy. I should say polygyny, because it's only allowed for one man to have several wives, not the other way around. There are 2 verses in the Quran addressing the issue of polygamy. In Surah 4, which contains most of the legal provisions, there is one provision saying that, especially regarding the orphans and the widows, it could be possible to have 2, 3, or 4 wives. But the requirement, one of the legal requirements, if entering into polygamous relations, is to treat all of them equally. And we have another verse later on in Surah 4 saying this is necessary, but man is so weak that it will be impossible to treat several wives unequally. And I must admit, while I don't have any personal experience in that, I can easily imagine that it is impossible to really treat a number of women equally in this kind of intricate relations. Traditionally, these two verses were interpreted as polygamy is allowed, but try to do best, husband, to treat your wives equally while everyone knows you will not succeed 100%. The Tunisian lawgiver after independence, and they have been arguing on the basis of Sharia, the Tunisian lawgiver said, no, the verse of equal treatment is the imperative one. And in our days at least, it is impossible to treat wives equally, and that's why we prohibit polygamy. So in Tunisia, while claiming Sharia rules for legislation in this point, even polygamy is punishable. This is just to demonstrate how flexible the system can be and how much it depends on the interpretation of the rules. And if someone says, many would do in Islam, God is the only lawgiver, God is the sovereign, even if you take this point of view as a starting point, nevertheless, all these rules have to be interpreted as to where they are valid, anytime or just in particular times, for everybody or just for certain persons, at any place or only at some places in the world. And of course, if such a system wants to perpetuate the normativity of Islam, it has to be flexible. Just one example from the religious point of view. There are now some hundreds of Muslims living in northern Finland. So this is a part of the world north of the northern polar circle. And as you know, in summertime, there will be no sunset at this place of the world. So if it happens that the month of Ramadan falls into summertime in northern Finland, if you take the old interpretations of fasting literally, these poor people, if they decide to stay there at their place, have to fast for 30 days without drinking, without eating, and so the Muslim population there will die from year to year. Can that be God's will? Obviously not. And so these people have to find new solutions because the circumstances of their lives have changed. And as I heard, some of them would take the times of Stockholm or for some other cities a bit south of the polar circles. Others would take Mecca, which is a bit more comfortable because the sunset is earlier there. But whatsoever, it simply demonstrates, and I think this is a kind of strength of Islamic normativity in the past, that it has contained a high degree of the possibility of adaptation to the circumstances of time and space. Not necessarily. We do have dictatorship. We do have suppression in the name of Sharia as well. So you can interpret it either way, and it's always human beings who are responsible for these interpretations. Interestingly, I'm just coming back from Cairo today. I had my breakfast still there, 30 degrees, can you imagine? Not the breakfast, the climate, of course. There was a debate in the Egyptian parliament and in the upper house now, and in the constitutional assembly, preparatory assembly for the constitution, who is the sovereign of Egypt. And interestingly, we do have there two so-called, I stress so-called Islamist parties. It's the party of the Muslim Brotherhood, the Hizb al-Hurriya wal-Adala, and it's the Salafis, Hizb al-Nur. But there are fundamental differences between the two. We shouldn't put them into one pot. The Salafis, Hizb al-Nur, fiercely backed by Saudi Arabia and other parts of the world, indeed wanted the constitution to be based on God as the sovereign. They wanted to have a provision, God is the sovereign. But not so the Hizb al-Hurriya wal-Adala, the Freedom and Justice Party, run by the Muslim Brotherhood. Now the constitution says the Egyptian people is the sovereign. So the people is the sovereign of the thing. And if you read their draft party program, you will see, of course, we acknowledge God is the last sovereign, God is the last reference, but human beings are the vicegerents of Allah, fil ard, the vicegerents of God on the earth. And so they do have the responsibility for legislation. And in a way, this is a secular thing. They don't use the term of secularity. because it is highly misinterpreted, I would say, in many Islamic countries, among many Muslims who would understand it as something of anti-religious. Secularism is equated to anti-religiosity, which is obviously not the case in secular states. If you take Belgium, if you take my country, Germany, or others, where religious life can develop in public space. In Germany, in the last 40 years, 2,700 mosques were built. So, in public space, of course. So, this is no anti-religious system at all. But nevertheless, nowadays, in these parts of the world, in Asia, for example, I would call the thing rather Dawla Madaniya, civil state, rather than secular state. But I think the contents of the bottle is very much the same. So, regrettably, there is no broad knowledge about this flexibility and this variety of interpretations of Sharia, even not in European administrations and courts sometimes. If you only take the verdict of the European Court of Human Rights concerning the case of the prohibition of the Refah party in Turkey, the Turkish party in 2005. I don't enter into details whether there is good reasons for having this party forbidden, yes or no. I just refer to the reasoning of the court, saying they wanted to introduce Sharia, and Sharia is the very contrary to a democratic state under the rule of law. I simplify a little bit, but that's the main content. And I know that some of the judges in the court are not very happy about this all too simplistic, blunt rejection of the system. If you ask people in polls here in Europe, if you ask Muslims, do you want Sharia here in Europe? And many of them would say yes, yes. So is this necessarily a danger for our legal systems, which of course we should defend? We should not negotiate democracy and the rule of law. But is this necessarily endangering it? Is this necessarily contradictory? No. Because if we know that many Muslims would perceive Sharia to be first and foremost a system of religious and ethical norms, of course they can say yes to that. And it's even protected under freedom of religion, which is an elementary part of human rights, granted by the UN Declaration on Human Rights, Article 18, granted by the European Convention on Human Rights, Article 9, granted by the national constitutions. So I thought for a long time you can't really ask silly questions, you can only give silly answers. But no, you can ask silly questions. And this is one of those. If you ask on this abstract level, what do you try to find out? What do you try to find out? That, okay, these are the others, they don't belong. They endanger us. And who is us and the others? Of course, it's Muslims and the rest. And it's totally wrong to ask like that, because if you ask people more concretely, you get the right answers. Do you want to pray? Do you want to have religious infrastructure in the lands you're living in? And if they say yes, okay, let's protect it under freedom of religion, and no objection to that. If they would say, I would like to enter into contracts, for example, on loans, taking no interest, this would be Sharia. This would be Jewish law, by the way, or medieval Christian law, equally. No objection to that. No one is forced to take interest for loans. So there are many elements of Sharia rules, even legal ones, which are not at all contradictory to the ruling legal orders in Europe. Others definitely are. Of course, if you ask people, do you want to introduce a system of family law, of inheritance law, which is contradictory to the ruling idea of equality of sexes, of equality of religions, of state neutrality, and if they say, yes, we want that to have to be implemented for everyone living here, this would endanger our system, this would challenge our system. But you have to ask this concretely to get the right answers. And all these polls, forget about them, if the questions are asked in this abstract way. A second point is of a certain importance as it comes to Muslim attitudes towards European laws, even if they would say our traditional system of Islamic law, which was developed over centuries, etc., referring to God as the last point of reference, is much better than these worldly secular laws in Europe. But even then, the next question has to be asked for these Muslims themselves, how to deal with these laws. And there is an old answer given by Muslim scholars since more than 1,000 years. Not by everyone, but by the vast majority. You know, theoretically, if we look at the international level 1,000 years ago, from a Muslim worldview perspective, there are two camps. There is the camp of Islam, Dar al-Islam, the abode of Islam, and there is the abode of war, Dar al-Harb. So, in theory, these are contradictory, these are in opposition towards each other, and Islam should try to conquer the others, the lands of the others, since Islam should be spread all over the world. At least people should be given the opportunity to get familiar with the religion of Islam. This is their basic idea, but it's relativized to a very, very important extent. In Islamic history, and then in theory, we have the phenomenon of truces, of peace treaties between Muslim territories and Christian territories or others in the world. Why? Because you can't always fight the others. And it's so useful to have contact, to have exchange in education, in trade, etc. Freeing slaves was an issue at that time as well. So the scholars developed a third in-between category between these two camps, which is the so-called Dar al-Ahd or Dar al-Sulh, the house of a peace treaty, the house of a truce, the house of a settlement. And Muslims were first entitled to go there, and Muslims were, from a Muslim perspective, required to obey to the laws of these lands, provided that they are granted security and basic standards of religious life there, which usually was the case. So, if a devout Muslim is living in a non-Islamic state, but is granted security, and they would explain nowadays, for example, by nationality or by a visa, residence permit, etc., this Muslim is obliged, not only by these laws themselves, of course he and she are, but also as a pious Muslim to obey to these laws. So security against obedience. This is the deal in this contract. And this indeed is an idea on which many Muslim organizations until nowadays in Europe would rely when developing a so-called fiqh al-aqaliyat, Islamic jurisprudence for a minority, for minorities. And we have several organizations here. We have a European one covering several European countries. We have some smaller ones.